And now, in studio, bringing his Midwest values from the Show Me State to the land of San Diego. He's a triple threat, licensed as an attorney, mortgage broker, and a top producing realtor who's crushing the competition. Here to deliver you what's happening in the trenches of the market. Your host, Michael Gaddis.
Welcome back to the Michael Gaddis Show on AM 1170 The Answer. I am your host, Michael Gaddis of michaelgaddis.com and frontierloangroup.com. I am speaking with Ashley Cairns of Sullivan Hill and Allison Soares of RJS Law. They are two of San Diego's top tax attorneys. Now, before I move on to the topics that we were going to talk about, during the break we were kind of just talking about what we were going to talk about next, but something just keeps pounding in my head that I think needs to be said. And I think what I'm saying is a lot of people are like, well, tax attorneys, why do I need a tax attorney versus a tax preparer or even a CPA? Can you kind of give us a difference of what it takes to be what you are and how you are different than some of the somebody claiming to be a tax preparer?
Yeah, we actually do not prepare taxes. We both are really distance ourselves from that. The tax preparer is a person to go to, and generally taxes are considered more black and white. Here's the substantiation, here's the return and how it should be filed. An attorney is your advocate. Attorney can take the information and portray it in the best light of what your intentions were at the time. It's very important to consider both sides when you're going back and filing your tax return to make sure that you're doing it correctly the first time.
And another thing you're going to want to consider is any type of conflict of interest. Now, this happens most often in the tax controversy arena, but if your tax preparer had prepared the return that's now under audit, they may have a conflict of interest to protect themselves from penalties while they're representing you. So you'll always want to be cognizant of that.
And I'll jump into that really quickly. This is a really important thing to consider if you're under audit, because the tax preparer goes into the audit meeting and they're defending their work. And they may go back and say, this was provided to me by the taxpayer. And, like Ashley said, to protect themselves, they're saying this is the information that was substantiated. Whereas an attorney may be able to go back and to review the information that was actually provided for the taxpayer, not what the tax preparer says to the government agency.
Well, I think that's a really good point, because I think there might be some people driving or sitting at home right now and they're like, well, I hear these tax attorneys talking, but how is that relevant to me? But it is relevant to you. This is one of the, there are certain, as I mentioned, certain words in our vocabulary that strike fear into people, and one of them I forgot to mention is the word audit, and you mentioned it, and that is a word that literally can terrify someone as much as just about any other word. And so what you guys are champions for people. What you do is you represent them using all the knowledge and skill that you have to try to get them through these dark times. You're like a guide through these dark times for them. Would you say that's true?
Correct.
Okay. So I just wanted to clarify for all of you that are driving right now that are thinking, whoa, why should I listen to this? This is why you should listen to this, because you never know when this stuff's going to happen, and you need to know where to go when it does. Okay? So we're going to continue a little bit on marital settlement agreements, and can they protect you? Ashley, can they?
No, not as much as you would hope they would. So the IRS and the Franchise Tax Board do not have to respect marital settlement agreements. The IRS only has to respect a court decree. And a marital settlement agreement does not hold up to that. So it's not enough that the judge just approves a marital settlement agreement. So sometimes the collection agent, who's the revenue officer, will say, well, do you have a court judgment? And the taxpayer says, yeah, I have a marital settlement agreement, and it's been signed off by the judge. The revenue officer will quickly come back to you and say, well, there actually has to be litigation, and the judge makes a determination as to who's liable for taxes and who's not. And most of the time that doesn't happen. The spouses tend to settle and agree on who's going to take what debts and what assets. Now, the caveat to that is the IRS and the Franchise Tax Board may consider a marital settlement agreement. So although they're not obligated to follow one, they may look at it and they may go ahead and pursue the spouse who's liable pursuant to that MSA. And the reason for this is if the IRS and the Franchise Tax Board do not respect the MSA, then the non-liable spouse, per the terms of that MSA, could go to family law court and seek contribution from the liable spouse. And so what I always say as a representative is, IRS, you may as well respect the marital settlement agreement now and go after the liable spouse per the terms of this, because otherwise I'm going to have my client go to family law court, seek contribution from the liable spouse, and then the liable spouse's ability to pay is going to be reduced by the amount of the contribution that they're paying. So at the end of the day, it all evens out. So unfortunately, they don't provide as much protection as you may hope, but there are other options for taxpayers.
Well, how about giving us an example? I mean, that's, you said a lot of stuff there, but let's bring it home and show somebody exactly what you're talking about.
Okay, so for example, I had a couple, and the husband decided to go ahead and take care of the tax liability, and the wife wasn't going to have to pay anything, and they agreed in this in the MSA. So the franchise tax board comes knocking and they say to me, Ashley, do you have a court judgment? And I said, no, but there is this MSA in place and it says wife's not going to be liable to pay anything and husband's already set up on an installment agreement. And they said, well, was this signed by a judge? I said, no, yes, it was signed by a judge. And they said, well, was there litigation? I said, no, there wasn't litigation. They agreed amongst each other about who was going to be liable. And they said, well, that's not good enough. And so I said, why are you going to make me go through the pain of going to family law court, having her seek money from her husband? If he has to pay her, he's going to have less money to pay you. And so they finally agreed to go ahead and put her on a non-collectible status so she didn't have to pay. So although they didn't have to follow it, they eventually did consider it and were amendable to not having her pay and just going after husband alone.
Well, let me get this straight, so let's see if I understand what you're saying. So a couple agreed that the husband would be responsible for any tax liability. The IRS came along and says, well, there's tax responsibility. Do you have, a decree, a judgment from the judge? No, but we have this agreement that we came to that the judge basically, signed. But they're saying that's not good enough. So why is an MSA not good enough, but forcing them, if they would have gone through litigation and had a judge actually decree it, would have been different, right?
Correct. And the reason is because of the joint and several liability that we talked about initially. When you filed married filing jointly, you're both liable for those taxes, and you can't contract around the tax law and the liability that you have created. So that's a rationale behind it. But like I said, if you're working with somebody reasonable, a revenue officer that's seen this a lot, they're probably going to consider it, although they are going to at least initially say, well, I don't have to follow it.
Well, I'm going to tell you something, that sounds scary to me.
Yeah.
I mean, if I'm a divorced person and I think everything's all resolved, and that's one of the things that I put into my MSA, right now I'm shaking a little bit, making sure, wondering if my ex-spouse is going to comply with his liability, or I'm going to be forced into something. Is that something that people should be concerned about?
Well, I wouldn't be too concerned about it, and it's something that you should be aware of, but I don't want it to strike fear in people, because there are a lot of options out there that you can explore even if the liable spouse decides not to pay under the terms of the MSA. If the liable spouse says, hey, listen, the IRS is going after you, that's your problem, and you could go ahead and seek contribution from me in family law court, there's other things that the non-liable spouse can do, and there's other options that we can explore with them that gives them an out or allows them to deal with it while they're trying to pursue their former spouse for contribution.
Well, you're listening to the Michael Gaddis Show on AM 1170, The Answer. I am here with Ashley Cairns of Sullivan Hill and Allison Soares of RJS Law, two of San Diego County's top tax attorneys. And so I guess my question is, what other options are available?
Well, like Ashley mentioned, excuse me, we do have currently non-collectible, like she mentioned. The one spouse is going to be on a payment plan. The party that is not liable for it is going to be in currently non-collectible. We can also talk to them about setting up an installment agreement. And that's working with the IRS or the FTB over a period of time and getting them set up on an installment agreement that they can afford to pay. And you want to make sure that we represent to the government that this is the actual financial ability if they're not willing to consider the MSA.
Well, let me ask you a question, because everybody hears horror stories about the IRS, and they're very difficult to work with, And how are they really that difficult to work with?
Actually, the IRS has a lot of national standards, and they have a lot of national rules that they go back and they have to enforce. The state of California, the FTB, the Franchise Tax Board, is actually much more aggressive, and they go back and file liens much quicker and potentially levies on clients much quicker than the IRS does.
And I would say the one thing to keep in mind is to not ignore the IRS or the Franchise Tax Board. A lot of times clients get scared, they stick their head in the sand, and they don't want to deal with it, especially when they're going through a divorce. The most important thing is to be responsive to the revenue officer or the Franchise Tax Board agent. If they know that you're working to resolve this issue, a lot of times they're willing to give you additional time to provide documents, to get representation, whatever your next step is. Just don't ignore the issue.
Well, I have to, and I'm going to be honest with you. I mean, anytime I get anything that says IRS or Franchise Tax Board, before I even open the envelope, my heart starts beating really fast, and I start looking like a deer in the headlight. I'm like, I don't even know what to do. I probably stare at that envelope for probably like 5 minutes looking at it, wondering what's in there, but I'm too afraid to open it. So you can understand people's reactions when they get these things, but you're right. I mean, putting your head in the sand is not going to make it go away, because the IRS will not go away. They'll just, they'll keep pursuing it, and pretty soon you could get to a point where it could be a very difficult situation to deal with.
Exactly, and a lot of these letters are form letters, and they can be somewhat hard to decipher, which is nice to have a representative be able to quickly look at it and tell you what this means and what the next steps are, and is there anything that you need to proactively do at this time.
Well, I think that's a very good point too, because when it comes down to it, seeking the advice of people who know is so comforting on so many levels. I mean, you might have a situation on your hands, but having someone on your side that fully understands how to deal with it and has been down this way several times before, it's comforting. I mean, it really is. I mean, it might be something that needs to be addressed, but at least you have your own champion going against a large entity like the IRS and the Franchise Tax Board. It's hard you can't do it yourself. I mean, I wouldn't recommend it.
And what's nice is we actually work a lot with CPAs and with family law attorneys and bankruptcy attorneys, because you're exactly right. They may know their skill set very well, and they reach out to us for some guidance on that. So we can prepare opinion letters, we can go back and see if the return was prepared correctly, and advise them how to either fix it or do it correctly going forward.
Wow, see, that's something a lot of people don't know. Just because you're a bankruptcy attorney, or you're a tax attorney, or you're an estate planning attorney, doesn't mean you know everything about all aspects of law. And some of these aspects of law are so wide-ranging and all-encompassing that it can be overwhelming, and so it's impossible for somebody to be really well-versed in every single area of law. So a lot of the attorneys that you're talking to, like she mentioned, whether it be a bankruptcy attorney, an estate planning attorney, all of these attorneys, they have the ability to seek advice on issues that they're not proficient in or 100% proficient in, and tax is one of them. I would imagine that you would be in a lot of people's speed dials, because you start as an attorney getting into a negotiation for bankruptcy or for a divorce. You want to make sure that you have yourself covered and your clients covered by getting competent advice.
And the tax law is always changing, and not only is the tax law changing, but also what the IRS is focusing on. So what we're seeing now is the IRS focusing on a lot of these foreign issues. Foreign issues come up in a divorce all the time. Payments to non-resident alien spouses, foreign bank accounts, and so not only knowing the ever-changing tax law, but also knowing what are key issues for the IRS, and so that you can at least tell your client, hey, you may want to look into this a little bit more, because if the client's prepared and they're not shocked and they know they have options, they're always happier at the end of the day.
Well, you're listening to the Michael Gaddis Show on AM 1170 The Answer, and we're going to go on break now, and when we come back, we're going to continue our discussion with Ashley Cairns of Sullivan Hill and Allison Suarez of RJS Law.